What's up, everybody? It's Jason Cruz here once again with another episode of The Legal Submission. And for this episode of The Legal Submission, we're going to take it back to June of 2024. And MMA Payout has obtained the transcript from the status conference in the Lee versus Zuffa antitrust lawsuit. Now, the relevance of the June status conference is the first time that Judge Boulware had a chance to discuss with the parties, mainly the plaintiffs, the proposed settlement of $335 million, which the parties had agreed upon after several sessions of mediation and stopping short of trial in April of 2024. The reason why I have the transcript now is because of the judicial process, which has the transcript with the court reporter and not available to the public until a couple months after the actual hearing takes place. However, I thought it would be relevant at this particular time to go over these elements that went over in the first status conference regarding the settlement, simply because we're heading toward a proposed trial in the Lee case. We are not sure what's going on in the Johnson case as of yet, but things will start to pick up sooner than later. So one of the first things that I note in this status conference, looking at the transcript, is that Judge Boulware has indicated to the plaintiffs that he had granted class certification for the Lee plaintiffs based upon the premise that they could prove damages between $850 million to $1 billion. He goes to say that, and I'm saying that to you because it seems to me that if the Lee class were by itself, a fair award would be higher. I mean, by my calculation, after we take out fees, right, you're talking about $160 million. So already he's talking about the fees, which fees and costs that attorneys will take out of the $335 million settlement, leaving the plaintiffs, to have a share of 161 between the Lee and Johnson class. So we see some issues from the outset because Judge Boulware goes on to ask plaintiffs about addressing those concerns, because really, he says, it seems to me part of the challenge, Mr. Kramer, Eric Kramer, plaintiff's counsel, honestly, is that these classes at this point, from my standpoint, have very different interests, and approving them together appears problematic to me. So why don't you address that? So Eric Kramer, plaintiff's counsel, states that as to the question about different interests, I don't think that they have different interests, and here's why. First of all, the reason why the Johnson case was filed in the first place was because we need to preserve the statute of limitations during the pendency of the class ruling. Otherwise, the Lee class would have just gone forward and it would have been one class. So it really is essentially one class. So that's the first point. The second point is that I think the opposite is true, that the Johnson class, by being attached to the Lee class, is benefiting. And that is particularly true, which the court acknowledges, Judge Boulware acknowledges, but he goes on to say that, however, they may end up a separate case, which is the actual what happened. They are separate, and I have to view them separately. I appreciate you saying essentially they're all fighters, and this is why they were filed separately, but I still have to view them as a legal matter separately. And we didn't have any issues, as far as I could see, with arbitration clauses with the Lee class, or to the extent they're not part of the class, right? And those arbitration clauses present issues, which is why they're capped awards to individuals with arbitration clauses in Johnson, right? So there's the issue with Johnson, is that there are arbitration and class action lawsuit waiver clauses that provided some obstacles for that particular class, as we can tell from the settlement, and the particular fact that the plaintiffs saw the award as in terms of cutting up the pie, 75%, 25% in favor of the Lee class. So the problem, overarching problem, is that Judge Boulware sees the issue being that he certified a class for $850 million to $1 billion, and they are getting $161 million. Now, the $850 to $1 billion is, again, the damages that were estimated by Dr. Hal Singer, as well as other experts that were retained by the plaintiffs. So the issue is that the plaintiff's counsel initially wants to have a very robust estimate to provide to the court to make sure that the court knows it's a significant case. But here, we see that Judge Boulware is holding them to that particular number. Now, the issue becomes, when it's time to settle the case, arguing to the court that the number that they settled for is sufficient. Now, the issue that becomes of this is that the class of fighters in Lee and probably in Johnson too are concerned with the fact that the judge is skeptical about why plaintiff's counsel settled for this particular amount and not the amount that they had estimated, the $850 to $1 billion. So the plaintiff's counsel noted that they had 3 mediation sessions over a long period of time, which we believe the settlement grew from those sessions. Whether or not whatever happened in those sessions isn't really relevant to what they can prove later on, simply because settlement discussions are prohibited as evidence later on. So the interesting thing here is that Judge Boulware found the experts of the plaintiffs credible, which so he says, he specific states, "You can understand from my perspective, I received these expert reports from your experts, which I found credible, which included certain dollar amounts, which I went through extensively in my order, and we had a hearing testimony as it relates to that, and I found that to be a credible damages amount." So from that perspective, the plaintiffs should be happy because they had a credible case to Judge Boulware. He had accepted as fact the theories provided by plaintiffs' experts, as well as the damages. Now, the problem and what plaintiffs' counsel talks about is that while they did have that estimate, there are great risks at trial. Regardless, with any case, there's always great risks at trial. And so the issue becomes, what are they? Is the settlement enough for the class of plaintiffs to satisfy those particular plaintiffs versus the risks of obtaining a higher amount at trial? Now, again, it's up to the judge, since he certified the class, to believe and make sure that the settlement is fair and adequate. So we are heading to a trial in February for the Lee class. The parties still could engage in settlement discussions, but it's clear that the settlement discussions must mean that Zuffa pays a higher amount, much more than the $335 million, if they are to settle the case. It's clear that the Zuffa is willing to defend this case. Mark Shapiro, at an investors conference, indicated as such that they were going to defend vigorously, that they would appeal the class certification, appeal any damages award, and fight this to the hilt. Now, he indicated that Judge Boulware should have preliminarily accepted the settlement and granted the settlement, with the proviso that anyone that disagreed, any fighter that disagreed with the settlement, could file their own lawsuit, which is misleading from a certain aspect, even though factually correct, a little misleading, and I'll explain to you why. It is correct that if you are party to the lawsuit and you are given a piece of paper that says we've settled the lawsuit, if you disagree, you can opt out of the lawsuit. Now, opting out of the lawsuit is a big endeavor if you feel as though you should continue on with the lawsuit, because you'd have to hire your own attorney, you'd have to fight you'd have to start all over again, you'd have to fight Zuffa by yourself, and this is why we have class action. So a similarly situated class of people who have been allegedly affected by a party or parties can bring a suit against them collectively, since the issues and damages are predominantly the same. You could argue about whether or not the damages are the same in this case, but for the perspective of the settlement here, it is the same. Now, it paints a picture from plaintiff's counsel perspective that they are getting grilled by Judge Boulware of their settlement amount, which he notes a couple times here that it's going to be about $161 million, not $335 million, based upon fees and costs being subtracted from that amount. The grilling may cause concern if you're represented, if you're the plaintiffs, one of the plaintiffs, who were anticipating that this amount of money would be life-changing. If you're a fighter that's aging, this has been a 10-year battle that's going on longer than anticipated due to a variety of things, and you're getting older and you are hoping that this money would help you with health insurance that Zuffa never provided. Stability as far as security in your retirement years. You're not going to, most of these fighters are no longer fighting, especially in the league classes. And the amounts that they could possibly receive could help change their life for the better. And that's the argument that plaintiff's counsel does make to the court. Again, Judge Boulware is thinking of the class overall, not just a certain amount of people within the class. And that's a hard thing to differentiate, because he thinks of the class as a whole, not just perhaps the top people that would be receiving a lot of money. Now, he does indicate a number of $2.5 billion to $4.5 billion based upon treble damages that the plaintiffs could receive if they went through and were successful in proving their damages. But again, it goes to the fact of going through this arduous task of litigating both cases and getting to a point where Zuffa would not take the case to an appeals court and virtually up to the Supreme Court. Plaintiffs had intimated that a Trump Supreme Court would likely strike down a huge dollar amount of an antitrust lawsuit. It would strike down a huge award from a jury awarding amount to working class people in an antitrust case. So basically stating that Trump has appointed 3 of the Supreme Court justices, which would suffice as a majority, along with the other conservatives on the court, in taking the case and striking down any award they would receive for a variety of procedural and legal reasons, not just because it's too much. So what happens next? Well, I think that what we could gather from this initial status conference is that Judge Boulware was skeptical of the settlement. He does go on, as we saw in July, he does go on and request from plaintiffs individual amounts that the fighters would be receiving, and how that and how it would fall in line with everybody in the class. To foreshadow a little bit, in July he was still had grave concerns regarding the settlement, and that's why he struck it down. He denied the settlement proposal by the parties. So he is anticipating that this lawsuit go to trial. And the concern is that you now, if you're the plaintiffs, you are expected to come in with an amount that is comparable to what Judge Boulware had indicated, which was around $850 million to prove. Now, it's one thing to prove the case, but then you'd also have to prove that the damages. Now, you could prove the anti-competitive means, but what about the damages? Zuffa has several. I mean, obviously they have a risk too, because they could get hit with a big amount plus the treble damages. But they still can play the defense in that plaintiffs still have to prove anti-competitive behavior, and that through that anti-competitive behavior, there were damages that flowed through that, and what those damages were. So there's a big big puzzle of pieces that the plaintiffs must go through to prove their case, and the amount of damages that they have to do to go through it. I'll leave you with an interesting excerpt here from, I believe it was Judge Boulware. Yeah, Judge Boulware, sorry. It didn't seem to me like you all had a de minimis chance of winning at trial, not saying that it's the standard, but I don't know that from the case that I saw that it seemed like you all had an exceedingly low chance of prevailing. Now, there's always a risk of going to trial, and maybe the risk something almost always 50-50, depending on how trials go. So, again, he seems actually like he thinks that the plaintiffs have a chance of prevailing at trial. Now, of course, he's hedging his bets. He's not saying, he's not giving a wink like he'll make sure that the plaintiffs win here, but he's saying that it wasn't like they didn't have a colorable case to present before the court, meaning that he thinks that they have a case. That's why he's denied motions to exclude the expert reports, because he again believes that they're credible. He's initially denied the motion to dismiss the case. He'll likely deny motions for summary judgment or any other motions before the trial happens, which would dismiss the case. Now, he says I don't know, from the case I saw, it seemed like you all had an exceedingly low chance of prevailing. So basically, he thought that they had a chance. He didn't think that it was just a Hail Mary that they would win this case. So there is potential to win, but also a great potential to lose. So that's the thing that plaintiffs' counsel was stating, is that the settlement is good because there are fighters now that could use the money, and a settlement would do that. It would bring the money now instead of having to wait for more time. But again, we see Judge Boulware hesitant to take this amount as a credible amount to settle this particular case. So we will see what will happen once we get the transcript from July's status conference. We'll contrast and compare what happens, as well as report on anything else that may transpire in the coming weeks for the Lee antitrust trial. This is Jason Cruz for the Legal Submission. Have a good one.